Good afternoon to all of you and happy June. I hadn't expected to be back with you quite this quickly. I'm subbing in for Kristen Smith, who has an unexpected conflict, but sends her warm regards to all of you. And it was a pleasure to see a number of you at the Westchester Workforce Conference, where I had the pleasure of delivering remarks. I'll see some of you later in the month at the New York City iteration of the same. And what I look forward to doing right now is walking you through the agenda for today. We've got a lot to cover and a lot to talk about. So I will touch on what's going on in the New York State legislature in just a moment. We're hustling to the finish line in the legislative session. Then Katie Schaefer, who is a member and who has been on this program a few times previously, is going to be talking about paid time off and some dynamics there from the perspective of her practice. Erin Torsello, who has also been on the program a number of times and has hosted, will be looking at clean slate implementation out of our Buffalo office. Chris Leone is going to be making his debut on the program, and he will be addressing the semiconductor industry, both in an historic fashion as well as looking ahead. There's some interesting implications, particularly in central New York, which Chris will get into. And then Jeff Gleason, who's been on the program a number of times previously, also out of Buffalo, will be looking at sports betting. And it's a topic that Jeff knows a lot about by way of his practice. So with that, Kathy, why don't we go to the next slide and quickly just want to make sure that all of you recognize that as far as the legislative session is concerned, we are getting near the finish line. If you look at that calendar at the bottom of the screen, you see there are blue dates highlighted through June 6th. That's the Assembly's calendar as to when it expects to be in active session. We know that at the end of the legislative session, there's always some wiggle room if there are important bills on the floor that the legislators think are close and they want to stay a little bit longer. They often do that. But many of the big ticket items, as it were resolved in the budget, which of course was finalized during the latter half of April. And so that both shortened the period for bills not relating to the budget and meant that many of the issues that were normally standalone bills in years past were tucked into the budget. So there is news in the overnight that there is agreement on a social media bill, essentially that would involve access to social media for kids who are 18 and younger, involving various elements of access, the way that algorithms are programmed in terms of the way content appears, etc. Details are unfurling. You'll hear more about that next week, but just flagging that. Another bill that seems to have made it through is, and these are in both instances pending the governor's signature, but they've gotten through both houses of the legislature in New York. The second one deals with postings relating to gun sales concerning safety in and around guns. Just noting that there are more details to come, but that is what is rumored to be soon to be signed. And then there are data privacy protections, which have in previous legislative cycles moved only so far, but other states have provided more robust data privacy protections than New York. And it looks like New York is looking to also pass some legislation potentially. We will know for sure, presumably by the end of the week. And then finally, the Grieving Families Act, which essentially extends rights to survivors of violence, and the exact form of it has changed year to year. There's another iteration of it moving through. It's unclear whether it will get through and ultimately to the governor's signature, but there seems to be some energy behind it. So more on that in next week's program for sure, at which point we expect the legislative session will have concluded and we'll be tracking bill signings and the like. But for now, let's move to our first speaker for the afternoon. And that's Katie Schaefer, who's a member out of our Syracuse office. I have the pleasure of working with Katie and also know that Katie is someone all of you know. She's presented on this program before, and she is here today to talk about PTO, and in her words, the answer you've been looking for or your worst nightmare. So let's find out, Katie, what do you really mean by that? And thank you all the more for coming on the program. We're really glad to have you.
Thank you so much. So yeah, I thought today we'd talk about a topic of unlimited PTO, which is kind of a new concept that I've seen, and I come across my desk a couple times of recent. It's certainly something that we've seen on the rise post-COVID. And not to be too dramatic, you know, the thought of, is this the answer you're looking for employee retention or a worst nightmare? So Kathy, if you could go to the next slide. So just so we're all on the same page, you know, your policy might look a little different, but when I say unlimited PTO, typically what I mean is a policy that allows employees to take as much paid time off as they desire, as long as they complete their work and meet all applicable deadlines. I think, you know, from a practical standpoint, this is something that could be applicable to all employees. I think it's much easier to be applicable to your exempt folks versus your hourly folks, but technically you could do it for anyone. Next slide, please. So some pros. Why is this attractive? Why are we seeing more organizations go to this option? You know, the obvious one is that it seems pretty amazing, right? You can have all the paid time off you want as long as you get your work done. So it's seen as a way to benefit, to address those labor shortages that we've seen post-COVID. To separate yourself from competitors. If you are competing against an offer for 2 weeks of PTO versus unlimited, you're going to sound better, right, in that labor market. It's another way of seeing to combat the employee retention issues that we've seen as well. So that's obviously a big positive, a big plus, a reason this is seeming attractive. Unlimited PTO offers your employees flexibility in their work-life balance and autonomy that, you know, I think the workforce has changed past post-pandemic, and those are things that some have come now to expect. So it's a way of meeting those demands of the labor force. It can alleviate those administrative burdens in tracking your employees' time off. If it's unlimited, you no longer have to track if they've met, you know, 5 days or 10 days or 2 weeks now. So that eliminates that burden for you. Another benefit is that it tends to be results oriented and focused on meeting those objectives versus a micromanaging approach of, you know, you're here from 9 to 5 and you can only take this day off. How many hours have you had off? Instead, we're focused on having our employees get those goals, meet those objectives, get the job done, get the project done. So it can tend to foster trust in that way. It can help your employees avoid burnout because they're able to take this PTO time. And there's actually a potential cost savings here, believe it or not. And when you think about your traditional PTO policies, many of them, including vacation, may have a payout on separation. So if you're not actually accruing them, which is what I would recommend based on drafting of this policy language, you're going to avoid those payouts at separation, which depending on your employee and the nature of your organization, they can be pretty large. Next slide, please. But some of the pitfalls. So, right, it's not going to be an option in all industries. If you're an industry where coverage is essential, I'm thinking like healthcare, for example, it may not be possible to go to an unlimited PTO model. And again, like I mentioned, it may not be the best for hourly workers as well. So another thing you want to keep an eye out for is that if you're not careful in drafting your policy, if you're not restricting it accordingly, you could find yourself paying for very lengthy family and medical absences that you don't want to be on the hook for. Thinking like FMLA, ADA absences, and now all of a sudden that's converted to a paid model, right? So you want to be thoughtful in that language that you're drafting. Another thing to be aware of is that it really does require strong performance management to ensure that that work is being completed and deadlines are being met. If folks can take off as much as they want, we want to make sure the work is being done. So performance management can be a challenge, and you have to have the right managers in those positions to be able to enforce this policy and make sure that the work is getting done according to your objectives. There can be an issue if you've got inconsistent enforcement of this or approval and time requests across your organization. If a different department One department tends to grant any request that comes across its desk. One department doesn't. That can lead to some inconsistencies, what can be a problem when you're looking at, discrimination complaints and why are people being treated differently, but also from a kind of employee morale, animosity perspective, that might not be the best thing for your culture. You might actually see employees taking less time off if it's unlimited. It's kind of a psychological thing where if there is a number listed at 2 or 3 weeks or 4 weeks, for example, it may be seen as giving kind of a guidepost as how much is expected. Sometimes I've seen policies like this actually sort of backfire, and employees assume, well, they're saying unlimited, but that really means they don't want us to be taking PTO. You can have some liability possible if you're commingling this kind of unlimited PTO with different types of leave that are required by law. So paid sick leave, for example, in New York State, and you deny that. So you really want to keep an eye on those. And again, that requires some careful drafting. If people are out of the office more, if they do take advantage of it, you may have that lost sort of face time, collaboration, mentoring, which is more helpful for your younger employees. So consider that and consider how much that factors into your organization. The other thing to keep in mind is that most places are moving to this from a prior system. So think about that transition and think about maybe prior leave that could be accrued that you may have an obligation to pay out and how you're going to do that. So if a cap is placed on those days, for example, that may actually trigger an obligation to pay out at separation under New York law. So again, just it's something you can't really do haphazardly. You want to put some thought into bringing it out. Next slide, please. So now we've talked about some of the pros, some of the cons. Let's talk about some of the best practices, some considerations. If you want to move to this model, what are some things to think about? So it's essential to have a clear written policy that's compliant with state and local law. It's not something you can put out on a, kind of verbal basis. You're going to want to have it in writing. You're going to want to think about all those pros and cons that we've talked about. One way to kind of address it and maybe make it more manageable for you might be to really think of it or even label it as an unlimited vacation policy versus an unlimited PTO policy. So instead of a very wide bucket of paid time off, we're talking really about vacation. We're not capping the amount of vacation that you have as long as you get your job duties done. Another option you might have is to limit the number of consecutive days that can be taken, for example, in a week or in a month. That might be a way of sort of capping it without putting a number on the maximum that you can have. We talked about policy language, so that's going to be important, having policy language to distinguish absences that are required by law, so FMLA, ADA, workers' comp leave, paid sick leave, those kinds of things, thinking that out and making sure that's well drafted in there. You're going to definitely want to make sure you require advance notice, advance requests, and approval from supervisors, and reserve the right to deny it if, it's a busy time, business needs or project deadlines are consideration. You don't want this to be a free-for-all where everyone can just take off whenever they want. So that's probably going to be an element that's important for most organizations. You may have certain times of the year where it is, we all know that we're under fire, we're very busy, and it might be difficult or impossible to grant time during that period of time. So that might be something you want to lay out ahead in advance in your policy. So you want to include policy language as well that the time doesn't accrue and doesn't get paid out at separation. New York still is typically very flexible in the sense of vacation that's required, but you do have to have a policy and you do have to comply with that policy. So those considerations are really important to make sure you're having in your policy language. And the last piece, again, that we talked about is considering how you're going to transition from your current policy. What are you going to do with accrued time that folks have? How are you going to pay that out? Are you going to keep track of that? So keep those things in mind as you're considering whether or not unlimited PTO might work for you. And that's all I have, Gabe. Thanks.
Well, thank you. That was a succinct presentation weighing the pros and cons and acknowledging, among other things, that we're in a changed world now that we're amazingly 4 years since the start of the pandemic. So thank you for bringing all of that to us, Katie, and please come on the program next time you have something for the audience to hear about. And let me now shift to our next speaker for the afternoon, who's Aaron Torsello, known to many of you as a regular contributor, and as I mentioned as well, an occasional host of this program. Aaron is based in our Buffalo office and part of our firm's core management, a member of the management committee, and is in her spare time a labor attorney, and also here in specific to tell us about the Clean Slate Act, which most of you are familiar with as really monumental legislation that affects various individuals who have had convictions and the treatment of those convictions from a workforce vantage point. We're getting closer to the implementation date, and it's time for everybody to really be thinking about its implications. So with that, Aaron, we'd love to learn more.
Great, thanks, Gabe. And that's a great introduction into this topic. As you had talked about at the beginning of the program, we are nearing the end of this legislative term, and this Clean Slate Act was actually passed this time last year in June 20 of 23. But at the time, Governor Hochul did not sign it for another several months. She ultimately signed it on November 16th, and it will be effective 1 year from the date of her signature, which is November 16th, 2024. So we've been living with this as a possibility for a year, but as you mentioned, Gabe, it's really starting to get to that point in time where we're 5 months out. Employers really need to start thinking about shifting their policies and practices with regard to background checks in order to comply with the Clean Slate Act. This is also a topic that we have covered in our employment law update in our statewide workplace seminar. So much of this, the introductory and kind of nuts and bolts information about the Clean Slate Act may be very familiar to most of you on this call. And I'm not going to get into the details of the act itself, but instead what I'd like to do is a quick summary of the requirements and the general obligations now that we have it as employers, and how this will impact your consideration of convictions in employment decisions. But I want to focus most of my 10 minutes on a few FAQs that we've had as a result of our workplace seminar. So just by way of very quick background, as Gabe mentioned, this law will seal certain New York State conviction records that will be unavailable in background checks and cannot otherwise be used by an employer to make employment-related decisions. So just as a quick overview, in terms of how the sealing will occur and what it will apply to. So for misdemeanor convictions, after a 3-year waiting period, which is measured from the end of the individual sentence, that conviction will be sealed. There are some exceptions to that if the employee is still on probation or prospective employee is still on probation, or if there's an intervening pending criminal matter or conviction. With regard to felonies, after an 8-year waiting period, again, that's measured from the end of the person's incarceration. All felonies typically come with some type of prison sentence. So a felony conviction after an 8-year period, again, would be sealed pending some limited exceptions. It's important to note that there are certain convictions that are completely exempt from sealing, and those include sex offenses, sexually violent offenses, as well as, with some narrow exceptions, Class A felonies. Otherwise, subject to those waiting periods, criminal convictions will be sealed from the use and therefore prohibited from the use in background checks and negative employment decisions. The other exemptions that apply here apply to not just the convictions, but certain types of employers or types of employment is also exempt from the statute. So for example, employers who are required or permitted by law to conduct a fingerprint-based background check, those would typically include employers in the healthcare, childcare, or elder care industries, are exempt from this law and can continue to consider what would otherwise be a sealed conviction in the process of either hiring or determining eligibility for continued employment. We do anticipate that New York may issue additional guidance with regard to our compliance obligations, but nothing's been released yet. And as is typical in New York State fashion, we typically don't see guidance prior to the effective date, or if it's prior to, it's very close to the effective date. But sometimes, as we saw with both the PFL and the PSL, sometimes guidance does not come out until well after the effective date has come and gone. So like I mentioned, we have about 5 months left until the effective date starts. But in the meantime, as we've been doing the workplace seminar, there are a few FAQs that we've been hearing from our clients that I wanted to share on the program today. So the first question for today is, what if a background check returns a conviction that's not subject to steal under the Clean Slate Act? What can I do? Can I consider that? And in this scenario, we will follow the same analysis that we currently follow under Article 23A of the Corrections Law. Just as a refresher, under Article 23A, an employer can make an adverse employment decision based on a prior conviction, so long as there's a direct relationship between the criminal offense and the job sought or held. However, in making that determination as to whether or not there's a direct relationship, Article 23A requires us to consider the following 8 factors. And again, as a refresher, I will mention those 8 factors again, but for those of you who currently do background checks, these will sound very, very familiar to you. So we first have to consider the public policy that New York State has to encourage the employment of people with prior convictions. We have to consider the specific duties and responsibilities of the job. We have to consider whether that prior conviction impacts the person's fitness for duty or their ability to perform one or more of the duties or responsibilities. So for example, if a person, as a result of multiple DWIs, has a suspended driver's license and part of their job is to drive, then that impacts that person's fitness or ability to perform one or more of those duties. And there's a direct relationship. You have to consider the time which has elapsed since the occurrence of the criminal offense or offenses, how old the person was at the time of the occurrence of the criminal offense, the seriousness of the offense, as well as any information that the person has produced to show that they've been rehabilitated. And then lastly, an employer is supposed to consider the legitimate interest of the public agency or the employer in protecting property and safety and health and welfare of either specific individuals or the general public. So that's somewhat of a catch-all. Keep in mind, while most employers do consider these 8 factors, it's really important as we navigate this that you document those 8 factors. We have seen that in Division of Human Rights complaints involving issues of or allegations of discrimination on the basis of a prior conviction. If an employer does not document the fact that they went through the analysis and specifically all 8 of these factors, the division tends to issue probable cause determinations, even if in our position statement and there's verbal recognition that the employer went through these 8 factors. If it's not documented, the division has been taking somewhat informally the position that it didn't occur and issuing a probable cause determination. So it's really important to document the analysis as you go through it. Next, what if after you hire an employee, you learn either through an internet search or one of your current employees that either an applicant or a new hire has a sealed conviction? So under the Clean Slate Act, again, we're going to presume this happens post effective date. You are still prohibited from considering that conviction, even if you didn't learn about it through a background check. If it is the type of conviction that is sealed and should be sealed under the law, we can't consider it regardless of how we learned about it. And then lastly, frequently asked question to address here, if we hire an applicant who passes the background check, but then we later learn that the applicant has a sealed record and it's related to some bad behavior at work, can we be sued for negligent supervision? And the Clean Slate Act actually specifically addresses this issue and protects employers in this scenario. So the statute actually prohibits a plaintiff from using a sealed conviction as evidence of any negligence against the employer if the employer ran a background check and the sealed conviction was not provided in the report. So while, you know, the Clean Slate Act is narrowing our ability to make decisions based on convictions, on the other side of things, the statute does provide some added protections for employers from negligent supervision claims. So as I mentioned, we're awaiting additional information from the state in terms of compliance. So as you are preparing your policies and procedures in anticipation of the effective date, please reach out to any one of us with any questions or concerns about how to comply with this new law. Gabe, back to you.
Thank you so much. There is a lot to mull over here. And as a presenter at one of those workplace seminars, I heard many of the same kinds of questions. So I'm glad that you had an opportunity to bring them forward here. It also appears that there are a number of folks who have questions that are in the chat. If you're able to attend to those, Aaron, that would be lovely. And in the meanwhile, I will both thank you, Aaron, for coming on as always, and please come back. And I'll introduce now our third speaker for the afternoon, who's Chris Leone. Chris is an associate who sits in Rochester and is someone who brings that really fascinating combination of experience in the patent world that certainly I admire in others. I don't have myself, and it's a combination of science and law that really has interesting applications to many different aspects of our business world. And one of them is very much percolating within central New York. It's semiconductors. We know that there are lots of business growth activities around that industry right now. And Chris is deep in it, wants to provide some background to this group as well as lens in terms of what might be ahead. Again, Chris is on the program for the first time. We look forward to learning, and Chris, looking forward to having you back in a future instance too.
Thank you. Yes, so my background is patent law. I work with inventors, I work with companies in protecting their intellectual property. And instead of discussing a particular issue in patent law, I thought it might be interesting to have a more general discussion of an important area of technology in modern business that we are all, at the very least, consumers in, that being the semiconductor industry. Next slide, please. So a simple but important question is, why is the chip industry called the semiconductor industry? Well, it's the same reason that Silicon Valley is called Silicon Valley. It's because the semiconductor industry begins with two of the most important inventions of modern times, the transistor and integrated circuit. Both these inventions resulted in Nobel Prizes in physics for their respective inventors. And the transistor is built on the semiconducting properties of certain solid state materials. And the most famous and popularly used semiconductor is silicon. Next slide. So like every earth-shattering invention, the semiconductor or the transistor and integrated circuit did not come out of anywhere. Did not come out of nowhere. Instead, they were the result of many individuals making incremental improvements over many years. And the semiconductor industry, as much as any industry I can think of, its history is reflected in patent filings. So here are just a few of the seminal patent filings that the semiconductor industry is built on. It begins with Lilienfeld in 1925 first filed a patent application discussing the idea of using an electric field to control a current in a semiconducting material. Unfortunately for Lilienfeld, when he was doing his research, the technology was not advanced enough at the time for him to do practical research towards building a actual working transistor. So his original patent kind of was lost to history for a little while until the 40s. A brilliant, but by all accounts difficult, scientist named William Shockley at Bell Labs had the similar idea of using a electric field to control a current in a semiconductor. and that this would have the possibility to replace the vacuum tubes that electronics were based on at this time. So Shockley, working with two colleagues, Bardeen and Bratton really worked to take Shockley's ideas and make the first practical transistor. And it was this point contact transistor. The patent was filed in 1948. That this is what the three of them, Shockley, Bardeen, and Bratton, won the Nobel Prize for in physics, this particular improvement. So Shockley, unhappy with sharing the glory of his ideas, continued the research and filed another patent solely in his own name for the bipolar junction transistor, which improved upon this, and this is a transistor that's still used today. However, it's not the main device used in our microprocessors. That honor instead belongs to MOSFET, which is a different type of transistor that in many ways is slower, less reliable than the BJT. But this is the device that all of our modern electronics are really built on, this MOSFET. That's because Attila and Kang recognized, the inventors of the MOSFET recognized that although it wasn't as on its face as efficient as the BJT, the MOSFET had an important property, that it was highly scalable. So that, combined with Jack Kilby at Texas Instruments, who invented the integrated circuit, a way of taking multiple devices and connecting them together, is what really allowed the semiconductor industry to take off. Next slide, please. So why is the MOSFET important and what is it? So MOSFET stands for metal oxide semiconductor. So if you look at this picture here, you can see metal, that's this 21 slab, oxide, 22 below it, and then semiconductor, this big block 12, field effect transistor. So these three layers, the MOS, form a capacitor that when voltage is applied to it, creates an electric field that can be used to control a current between these two terminals, 16 and 17. So why is this important? Well, this is important because it allows for very efficient switching on and off. On and off can be used to encode 1 and 0, which is our digital logic that all of our code is built upon. And notably, what really makes MOSFET king is that it is highly scalable. It's easy to manufacture all on the same silicon base. You can build a bunch of these devices on there, and it has the nice property that up to a certain point, the smaller you make it, the more efficient it becomes. Next slide, please. So traditionally, the semiconductor industry advances according to what's known as Moore's law, which is, since transistors, the number of transistors on a chip can normally be taken as a proxy for the computing power. The more transistors we can fit on a chip, the more powerful our chips become. And since MOSFETs become more efficient as they get smaller, the chip overall becomes more efficient, which you can imagine when you have billions of transistors all on the same chip, switching on and off, making the ones and zeros. It's important to have that as efficient as possible. You want to waste as little energy doing that switching. So Moore's law is not a physical law of nature in the same vein as Newton's F equals ma. Instead, it is an observation and in some ways a challenge to the semiconductor industry that the number of transistors on an integrated circuit doubles every 2 to 3 years. And for decades, this has held true. This is how the semiconductor industry has exploded over the last few decades. Next slide, please. So how do we progress through Moore's law? How do we fit more and more transistors? Well, we improve the manufacturing process. As a result, the manufacturing process has become extremely expensive, extremely complex, and extremely specialized. For time's sake, I will not go through these particular steps, but the point is that in order to make manufacturers is extremely expensive, and it requires very sophisticated knowledge. You combine that with Moore's law, which shows how fast this industry progresses. So if you fall behind on 2 years of investment, your competitors' products have twice the computing power of your products. All of these economic pressures have pushed the semiconductor industry towards greater and greater specialization. More companies have realized that it makes more business sense that instead of maintaining and setting up an expensive foundry, where I'll just design the chips and have someone else, a specialist, make the chips. Next slide, please. And that has led to the rise of Taiwan Semiconductor. Taiwan Semiconductor is the world's largest independent semiconductor foundry, and it is where the majority of chips in the world are made. Taiwan Semiconductor is the brainchild of Morris Chang, who was an executive and engineer at Texas Instruments around the time when the integrated circuit was invented there. And Taiwan Semiconductor was created with heavy support from the Taiwanese government, and then along with a key outside investor being Royal Philips that allowed it to get off the ground. So Taiwan Semiconductor's business model is they don't design chips, they build chips based on customer specs. So in this way, all the biggest semiconductor companies, Apple, NVIDIA, they are not competitors of TSMC, but rather customers. Next slide, please. So if semiconductor companies aren't making chips, what are they doing? Well, many of them are fabless companies, meaning that they don't fabricate their own chips, but design them. For example, your iPhone chips, they're designed by Apple, but made by Taiwan Semiconductor. NVIDIA designs chips that are especially suited for training deep learning AI. And again, those chips are designed by NVIDIA, made by Taiwan Semiconductor. Other businesses do both design and manufacture chips, but they tend to be more specialized. For example, Samsung and Micron specialize in memory chips, and then Texas Instruments, similar with analog chips. And then yet other businesses focus on particular aspects of the manufacturing process. For example, there's a Japanese business that focuses on just making the silicon wafers that are sort of the starting point of semiconductor manufacturing. And then ASML is an interesting Dutch company that they focus on just the photolithography process, which is used to draw the features onto chips, which is very sophisticated, very complex technology. Next slide, please. So the economic forces have pushed the semiconductor industry towards more and more specialization, which is a problem from a strategic standpoint, a geopolitical standpoint, where most of the world's chips are built in Taiwan, which is a geopolitically vulnerable area. To combat this fact, the CHIPS Act was signed in 2022, and this attempts to sort of fight against the natural economic forces pushing towards specialization in the chips industry by providing subsidies and government investment to promote chip manufacturing in the US. This, again, is a strategically motivated bill. It generally bars Chinese companies unless they receive a waiver. And then there's also other considerations given in funding. And then notably, the CHIPS Act doesn't only talk about semiconductor technology, it talks about many areas of cutting edge technology, but certainly has an emphasis on semiconductor manufacturing. Next slide, please. So along with this strategic issues facing the semiconductor industry, it's people within the industry are also facing perhaps the greatest challenge yet, which is Moore's law is ending. We've gotten so good at making chips, we've gotten them so small that the principle the area we're working with has completely changed. We're now dealing with strange quantum effects. An electron is supposed to be here where it's there, now it's there. So making them smaller and smaller is no longer feasible. We have to find new ways to continue to improve our semiconductors. And there are many different methods being tested currently. And then these are three just very broad ones, one of which is to try new principles of operation. For example, traditional electronics are based on the idea that electrons have charge, negative. But if it's the idea is instead to make a spintronic transistor where electrons also have a property called spin, where they can be either up or down. And this is a fundamentally quantum property. So the idea is you make a quantum transistor. Maybe that will naturally work better in the quantum world. Another idea is new materials. We can make channels in the transistor with carbon nanotubes. This would be highly conductive, highly resilient materials. We might be able to do this to get better switching on and off. And then a last possibility is artificial intelligence. As I'm sure you are aware, we are living in an AI revolution. So instead of making chips smaller and smaller, what if we make chips specifically in mind to work better with AI, and then we let the AI come up with more elegant algorithms that compute problems in a more efficient and faster way. These are just some possibilities, and there are many more ideas being bounced around and seriously invested in the industry at the moment. So to conclude, I hope this gave you a picture of some of the main inventions underpinning the semiconductor industry and some of the challenges it's currently facing.
Chris, absolutely, it provided that nature of underpinning you were hoping for, and it gives context to a lot of the activity that we're seeing, whether in central New York or more broadly in the geopolitical space, as you described. So yes, thank you very much for taking the time to walk us all through this, and please come on back to the program in a future instance. For now, though, let me turn to our final speaker for the afternoon, and that's Jeff Gleason. Jeff is with us from Buffalo, where he's a member. Jeff also does a significant amount of work in business generally, but with attention to gaming, and in that context knows a substantial amount about sports betting and other elements in that ilk. He's been on the program before to walk through some of that, and is here with some updates, having gone to what I understand was a pretty instructive conference, and some new ideas that are circulating that are worth all of us hearing about. So Jeff, please go right ahead. Glad you're back, and look forward to learning.
Thanks, Gabe. So as Gabe said, I've been on here before. We've talked a little bit about New York's casino expansion efforts, as well as prior to that, the launch of sports betting here in New York. But what we're going to talk about today a little bit is the swing back of the sports betting pendulum. Following the overturning of PASPA in 2018, we saw a lot of states adopting sports betting legislation, allowing for sports betting in their states, whether it be at a brick and mortar casino or online through an application on your phone. New York has obviously both of those options. But we're seeing, as a result of some controversies and scandals even in professional and college sports, a swing of that pendulum, and some maybe reconsidering as to what kind of bets we should be allowing. So I'm going to go through a couple of the scandals first, and then talk about some of the response that we're seeing. If you can go to the first slide, Kathy, please. So, a lot of you probably heard about this scandal. This came up in March. Ipe Mizuhara is the official interpreter of the Los Angeles Dodgers superstar Shohei Ohtani. He was originally from Japan. Shohei Ohtani this past year signed a new contract with the Dodgers for 10 years, $700 million. So there's a lot of money out there, a lot of big dollar signs being thrown around. And as a result of that, sometimes you have, some ancillary issues that come up. This one in particular involved his translator betting in offshore illegal sports books. He racked up approximately $40 million in losses. He had these massive debts owed to these bookies overseas. And so as a result of that, ended up dipping into Shohei Ohtani's bank accounts, and in a lot of instances, transferring money directly to these sports books. There were 39 total transfers of varying amounts, from $500,000 to over $1 million, totaling, as you see here, nearly $17 million to pay back these debts. This was discovered. He quickly, kind of went to an explanation that these were loans that Shohei Ohtani was lending his friend in order to pay back these gambling debts, but later admitted that they had not been authorized by Ohtani, and this was theft. Today, actually, Mizuhara is in court pleading guilty to 2 felony counts, one of bank fraud, one of submitting a false tax return. This will include full restitution to Shohei Ohtani of the amount stolen from him. If you can go to the next slide. This is another one of a recent scandal that's come up in the NBA involving Jontay Porter. Jontay Porter is a two-way player for the Raptors. Just to pause there and explain, unlike Ohtani, who is also a two-way player, in baseball, it means he's a great pitcher and a great batter. In the NBA, a two-way player is a little bit different. A two-way player is someone who's basically on the end of a roster of an NBA team. Each NBA team is allowed to have 2 of these contracts each year. It allows the player to kind of be called up almost from the minors. In the NBA teams have G League affiliates. So when they're not playing in the NBA due to, a player's absence or an injury, they play for the G League affiliate. So, this status on the end of the roster really plays into kind of, what we're going to talk about here. Jontay Porter specifically had an associate place bets. This one was an $80,000 bet to potentially win $1.1 million on an under. So Jontay Porter, there was a line set by a regulated sports book in Colorado that, let's say Jontay Porter to score 3 points, and he placed the under bet, meaning he was betting that Jontay Porter was not going to score 3 or more points in that game. Following that, the NBA investigation found that not only had Jontay Porter communicated some of his injury status, which is confidential information, to someone who wasn't authorized to receive it, but also that he influenced the outcome of that bet by claiming that he fell ill during the game and left the game before hitting the threshold for that under bet, meaning the under bet won. However, this was caught by the sports books, reported to the NBA as well as law enforcement. And Porter, maybe just the beginning of his troubles here, received a lifetime ban from the NBA for these actions. If some of you saw yesterday, Padres infielder Tucupita Marcano also got caught up in a scandal like this. He was betting on the team that he played for. He was injured, so he wasn't betting on himself. It's a little bit different than Jontay Porter, but he was betting on his own team that is against the rules of Major League Baseball. And today it was announced that he has also been banned for life. You've seen some kind of more modified suspensions, not lifetime bans in the NFL, the NHL. The NCAA has kind of had a lot of these investigations. Back in July of 2023, it was announced that there had been 175 violations discovered between 2018 and last summer. There's been more that have come out this year. If you recall, the Iowa State, student athletes, many student athletes across multiple sports for both of those schools, got caught up in some of this, sports betting scandals, had received various suspensions. And the Alabama baseball coach, Brad Bohannon, was fired last year after it was discovered he was betting on his team illegal or with regulated sportsbooks, but against the rules. We go to the next slide. So let's talk a little bit about kind of the pushback. Again, I described this as a pendulum. We had this push towards expansion of sports betting in multiple states. Now we've had some scandals, and we're seeing kind of some swinging back of that pendulum, some pushback from the leagues and from the NCAA. The NBA, after the Jontay Porter scandal, is a little bit on the forefront of this. They've proposed a framework to limit prop betting. Specifically, as we talked about this two-way player issue, they are talking about asking sports betting operators to prohibit markets. That's what we call kinds of bets, to prohibit bets where a two-way player is involved, whether that's even an over or an under bet, or minimum contract players. These are the players that are kind of most susceptible to seeing if they can get a little bit of extra money, because again, they're not guaranteed their contracts. They're not on the LeBron James or Kobe Bryant level of multi-million-dollar contracts. Their contracts are just not worth as much. They're not receiving as much money. So some of them see this sports betting as an opportunity to get a little bit more while they're still playing. Admittedly, Adam Silver here, he said that there's only so much the league can control. There's a little bit of this that is instructed by previous experience by the professional sports leagues. After PASPA was overturned in 2018, you saw a lot of leagues trying to push for an involvement in the legislation process, asking for integrity fees to be payable to the leagues to monitor some of this. They largely lost all those fights. So they're admitting kind of there's only so much they can do here, but they are pushing for this kind of structure to be put in place voluntarily by the sports betting operators. Next slide, please. This is the last one. We're going to talk about the NCAA. Charlie Baker here, the president of the NCAA. He's got a strong push right now to remove player prop bets on in college games. We've seen bans go into effect in Ohio, Vermont, and Maryland. Louisiana has a ban coming effective this summer. The college players, especially, remember, a lot of them aren't being paid at all. There was recent settlements allowing for some monies to be set aside for college athletes. And we've had over the course of the last year plus this discussion about NIL deals, but largely you have NCAA student athletes who might see this path into sports betting as a way to get some money for their athletic contributions. There's a lot of work going on now too to cut down on harassment of student athletes. Student athletes are particularly susceptible to kind of harassment by bettors who aren't affiliated with the NCAA institution, who are either mad that the college player did not meet the level of competition that the bettor expected. Unfortunately, you also see death threats and things come out of these when bettors lose money. And West Virginia has legislation pending or proposed right now to exclude those bettors who are found to have engaged in harassing behavior from betting at any of the West Virginia sports books in the future. That's one way to go. The problem that we see here, from the operator and the league and NCAA side of things is a fine line to walk. We have potential bans on types of bets that can be made. Operators don't really want to restrict the kinds of bets they can offer. Prop bets, whether we like it or not, are one of the more popular kinds of bets in sports betting right now. The U.S. consumers love to bet on players hitting over or under a number of points or rebounds or goals or touchdowns or whatever it may be. So it's just become a very popular way of betting. The other part of this too is that when you introduce legislation to remove some of those sports betting markets, you end up pushing more people who still want to participate in that kind of sports betting into illegal books. And that's becoming kind of even more ingrained in our digital society. Whether you know it or not, if you've been on social media and scrolling through, reels or whatever it is, you've probably been pitched a, offshore or illegal sports betting operation in those videos. It might be subtle, it might just be a little reference, or it might be actually promoted by one of these offshore sports books, and we're kind of really not focusing on how to solve that. I'm planning to go on our podcast. Little plug there for the podcast, the Bonds podcast, in the future to talk about that, that advertising and regulations proposed to regulate that. But for now, this is the status of sports betting in the U.S. We've got this kind of push and pull resulting from some recent scandals that have happened. And now you have the NCAA and the NBA, at least, more leagues probably to join soon to push for, some of these bets not to be offered anymore.
Yeah, really interesting. Thank you for providing an update on as you described it, this pendulum, and certainly it is swinging. And so we look forward to those updates. For those of you who don't subscribe, the podcast is legally bond, and you can access it through all the places you get your podcasts. Let me, in the last few moments, though, knowing that we are a few minutes over today, first thank Jeff for the time that Jeff's taken to present. I'll remind you as well about the remaining workforce presentations. Those are on Long Island, June 6th, New York City, June 11th. I'll be personally presenting at the latter. Let me also tell you about a presentation, the fourth in a series that the Office of the Medicaid Inspector General is doing with Bond. These are webinars. The next, fourth will be tomorrow at noon, if you'd like to register for that. And if you are involved in healthcare and healthcare compliance issues, just reach out to me directly at goberfield@bsk.com, and I'll make sure you're registered. In the interim, if you want to be in touch with any of today's presenters, you have the email addresses for them right there. You can always contact me, and I will also facilitate. In the interim, though, we hope that you have a terrific balance of the week. We look forward to having you back with us later this month, next Tuesday, ideally, for our next installment of Business in 24. And in the meanwhile, wishing you a terrific afternoon.